You don't recall seeing show me, because what some people are saying is that the IRS was used at a local level in Cincinnati, maybe other places, to
Absolutely
go after.
wrong.
But how do you know that? Because we still don't know what happened there.
Bill, we do. That's not what happened. Folks have, again, had multiple hearings on this. I mean, these kinds of things keep on surfacing, in part because you and your TV station will promote them. But when
don't
folks
you feel
actually,
there are unanswered questions?
Bill, when you actually look at the stuff, there have been multiple hearings on it. What happened here is that you've got a 501c4 law that people think is confusing. That the folks did not know how to implement. Okay. Because it basically says,
so you're saying if you're involved, no corruption there at all? No.
That's not what I'm saying. That's actually...
No, but I want to know what you're saying. You're the leader of the country.
Absolutely.
You're saying no corruption? No. None?
No. There were some boneheaded decisions out of a local
but no
office.
Mass corruption?
Not even mass corruption. Not even a smidgen of corruption, I would say.
Okay.
Thank you so much for inviting me here to speak. I can't tell you how much I do appreciate you holding this hearing. Unfortunately, I'm not here to carry a message of joy or thanksgiving. I'm in absolute grief for my beloved country. 8 months ago, I, along with 5 other victims, eloquently laid out our cases about the IRS abuses in a committee just like this. And at that hearing, we learned details about the IRS leaking confidential donor information to opposition groups. When proven, this is a felony. We learned of serious constitutional violations of the First and Fifth Amendments. We witnessed multiple violations of the Administrative Procedure Act, as well as violations of the Internal Revenue Code. Lois Lerner outright lied to the American people, blaming this scandal on a few rogue agents in Cincinnati, knowing full well that the targeting involved IRS offices across the country, including her very own office in Washington, D.C. Lois Lerner took the fifth for a reason. Government employees don't go rogue en masse. Their orders originate somewhere. Yet even with all these known violations of the law, no one has been blamed, shamed, fired, arrested, or brought to justice. And because of that, I have to ask, how many people in Congress are taking this seriously? Since my last testimony in Congress, I still have not been contacted by the FBI. The FBI told the Wall Street Journal that no one would be charged with the crime. Yet they haven't even interviewed the witnesses. Are you going to let them get away with this? If so, then I must say it again. My government has forgotten its place. It appears that many in Washington fear regular citizens standing up for constitutional limited government. Why in America is it now considered a threat to our government to study the founding documents and to advocate for responsible spending? Why is giving out copies of the Constitution, discussing pending legislation, or even creating legislative scorecards a threat to this administration? Obviously, these activities are viewed as subversive to their agenda. Otherwise, they wouldn't have tried to stop us. In my previous testimony, I explained that our application was complete and accurate. We easily qualified for a 501c4 status. Yet that did not stop the IRS from demanding information they were not entitled to, unconstitutional requests that violated even their own rules. The information they demanded from us had nothing to do with our tax status. Why must the IRS know who's coming to our meetings? Why did they need to have copies of every speech ever given and the credentials of those speakers? Why did they need to know who our donors were? There is clearly something wrong with this. The IRS's targeting of the Wetumpka Tea Party and other conservative and religious groups is profoundly disturbing. I'm offended that a member of Congress, of the United States Senate, would continually request the IRS to go after Americans like me because they do not agree with our values. This is unprecedented. Never before has the federal government tried to muzzle everyday Americans solely because of their political view. The governments of third world nations intimidate and harass dissenting citizens. It does not happen in the land of the free until recently. It's shocking, it's pathetic, it's infuriating and depressing. But most troubling of all is Congress has not stopped us. It's actually gotten worse. During these past 8 months, Congress has quietly sat by while the IRS has proposed to cover up their targeting by rewriting the rules for 501c4s. Rules which are an ardent attempt to shut us down completely. One of our most sacred fundamental rights in this country is freedom of speech. But the IRS, under this administration, wants to strike out 226 years of history with a keystroke. Under these new rules, we are not allowed to use the words oppose, vote, support, defeat, or reject. We're not allowed to mention on our website or in any communication that would reach over 500 people, even the name of a candidate who is running 30 days before a primary or 60 days before a general election. We are not allowed to mention the name of a political party if they have a candidate running for 60 days before an election. No more voter registration drives, no more conducting nonpartisan get-out-the-vote drives, no creating or distributing voter guides outlining incumbents' voting records. We can't even host candidates for debates or forums less than 60 days before a general election. Our officers and our leaders cannot speak publicly about incumbents, legislation, and or voting records without jeopardizing our tax status. Does this sound like the land of the free or the home of the brave to you? The political targeting carried out by the IRS is a fundamental transformation of the America that we all grew up in. Like Catherine, I am not here as a victim because I refuse to be a victim. I am a born free American woman, and these abuses of power put all Americans' liberties at risk. Our government is using its agencies as weapons against its own citizens, and history shows that unaddressed abuses of power lead to greater abuses of power. I, along with my fellow Americans, are looking to you on this committee to restore the faith that you really do represent us. We implore you to use the full force of the law to stop these abuses immediately and to bring to justice not only those who gave the orders, but all who helped carry them out. I want the federal government to know, and the IRS to know, that you will not divide us, you will not conquer us, and we will not be silenced. Thank you.
Thank you, Ms. Gerritsen. Mr. Sekulow.
Chairman Jordan, Ranking Member Cartwright, and distinguished members of the subcommittee, on behalf of the American Center for Law and Justice, thank you for allowing me to participate in today's hearing. I represent 41 organizations that have filed a federal lawsuit against the Internal Revenue Service. My first job out of law school, a long time ago, was with the Office of Chief Counsel with the IRS. I was a trial lawyer for Chief Counsel's office. I'm proud of that heritage in my legal career. I am disappointed and dismayed with what the IRS is doing even today. I have prepared comments. I'd like those to be made part of the record. Thank you, Mr. Chairman. I'm going to deviate from those for a moment because of a recent revelation. But before I do that, Mr. Cartwright, I'd like to give you some information about the progressive versus conservative groups that were targeted. And indeed, there were some progressive groups that were put in this list. However, this is the IRS's own statistics through July 29th of last year. 104 conservative organizations, according to the IRS, had been targeted. They were asked 1,552 questions. The average question per group was 15. That did not include the subparts. 48 were approved, which is an overall approval rating of only 46%. Indeed, 7 progressive groups somehow got caught up in this dragnet because of their names. They were asked a total of 33 questions, or 4.7 questions per organization. 7 of them were approved. That's 100%. This wasn't an equal opportunity discrimination. This was targeted discrimination coming from the Internal Revenue Service. And what I'd like to address now is that our view is that that determination came from the highest ranks of the Internal Revenue Service. Just yesterday, it was brought to the public's attention that an email had been sent by Lois Lerner, the former head of Tax Exempt. She played the Fifth Amendment. Based on the evidence that came out yesterday, if I was her lawyer, I would have told her to plead the Fifth Amendment also. And here's why. An email from Lois Lerner was sent with Ruth Madrigal from the Office of Tax Policy, United States Department of the Treasury. It went to Janine Cook, Deputy Division Counsel and Associate Chief Counsel of the IRS Tax Exempt and Government Entities Division. It went to Victoria Judson, Division Counsel, Associate Chief Counsel, Tax Exempt and Government Entities Division. It went to Nancy J. Marks, Division Counsel and Associate Chief Counsel for Tax Exempt and Government Entities, and a senior advisor who conducted a probe for Stephen Miller, by the way, with Holly Paz into the impropriety months before this email. What was this email? It was an email that we will work, quote, off plan to devise rules to curtail the activities of 501c4 organizations. Off plan. That's very different from saying 2 rogue agents in Cincinnati. So if I was Lois Lerner's attorney, I would have told her to plead the Fifth Amendment too, because there's serious liability. With regard to the facts of this case, we have 41 clients. Late in December, I was contacted by the United States Department of Justice, the FBI, and Ms. Busserman was on the call as well. They had requested at that point that they might want to, after the first of the year, interview 3 of our 41 clients. They said they'd get back with us after the first of the year. They did, and about the same day they got back with us, of course, the announcement about Ms. Bosserman's political contributions was made public, and that was followed up by a statement in the Wall Street Journal by an FBI source that there was indeed no criminal investigation. My office's comment back, and by the way, the lawyer in my office that is tasked with dealing with the FBI on this is a former assistant United States attorney. If there is no criminal investigation, why do you need to speak to our clients? No comment. They said they will not discuss the ongoing investigation. The next question, which I think is a very serious one, is the fact that the FBI, in desiring to speak with our client, we raised the concern of Barbara Bosserman. And Mr. Cartwright, again, with due respect, it's not because of her capabilities as a lawyer. I'm sure she's a fine lawyer. She's a career lawyer. You cited an ethics rule. And then, Chairman Jordan, you cited the real rule. The obligation's not on the Department of Justice for something like this. It's on the lawyer.
Exactly.
The lawyer has to avoid the appearance of impropriety. And if you're heading up the investigation, and we're assuming she is, no one's ever been very clear on that, you can't head up the investigation in an impartial method if the public thinks there's even potential for bias or an inappropriate position. It was very simple for the Department of Justice to solve this. They didn't have to go in and ask her political position. She should have she has the affirmative obligation to tell her supervisor, I could be compromised in this. It would be best if someone maybe from public corruption took a look at it. I'm just saying that for the record so that we're clear on the evidence. But what we have right now in the few moments I've got left, Mr. Chairman, is...
She could have said that. And the department says, no, we want you to head the investigation. No, that's my hunch.
That's why I'm saying that I don't want to impugn her integrity. I don't think it's fair to do that because I don't know what statement she made. But she did have the obligation. But let me say this. The IRS attempt now to change the rules falls on 2 systematic problems. Number 1, you don't get to change the rules for a post hoc justification of your prior bad and illegal conduct, number 1. And number 2, remember that the acting commissioner, when this first broke, proposed a scenario where he would do a 40% self-certification to grant exemptions to these C4 organizations if they would self-certify, that no more than 40% of their activity was deemed political. Now, my clients did not exercise that. But if some client of some lawyer did exercise that, because there are over 300 of these groups that were targeted, if they did exercise that, how would you like to be the lawyer that told their client to exercise the 40% rule, and then 9 weeks later, the IRS say, oh, by the way, 40%, we've just changed the definition of political activity. You don't get to change the rules in the middle of the game to justify your bad behavior. Thank you, Mr. Chairman.
Thank you, Mr. Sekulow. We appreciate that. Recognize the Vice Chair of the Committee, Mr. DeSantis.
Mentioned, I think, very eloquently that you're going to keep fighting, and I see that, obviously, but when you have to deal with this, I mean, you have a business, you have other things, you're trying to impact the country in a positive direction. When you have to deal with these agencies like this, it makes you less effective in pursuing your message. It has to. Am I right in saying that?
It certainly gives one pause to think that there is interagency collusion against private citizens. It is the weaponization of government.
And do you think that people similarly situated to you may look at what happens to people who speak out, and they may just decide, look, I don't want to deal with that, and so I'm gonna just remain silent because I don't want to buy myself problems. In other words, this type of targeting can chill political speech. Do you think that that's true?
That's absolutely the case.
Ms. Gerritsen, what was the IRS asking you to provide? It seems like these were very invasive and intrusive questions.
They sent me a list of approximately 80 questions. It was an 8-page document. some of the questions they asked, they wanted to know all of my members' names. They wanted to know volunteers' names.
Which, by the way, I mean, we already know Lois Lerner has disclosed for tax information that she got caught red-handed in an email. So this stuff's supposed to be confidential, but we know that a lot of times it's not kept confidential. So continue.
They wanted to have copies of every speech that was ever given. They wanted credentials of who those speakers were. They wanted to know if any of our members or volunteers were going to run for office, and if so, what office. Remember, this was the 2012 election cycle when we got this questionnaire. They wanted to know they wanted to know any communications that I have had with any legislative body, even within my own representative. They wanted emails, phone contact. They wanted to know what I was saying to my legislator.
So I'll ask a similar question for you. Just seeing that, a lot of people getting involved in politics for the first time, you're seeing all these questions. Do you think that some people just look at that and say, I don't want to have to deal with this? In other words, does this cause some people to silence themselves?
Absolutely. We have a group in Alabama who said they got their letter and said, we're not going to do this. And they stopped.
Ms. Mitchell, do you agree with Mr. Sekulow, this idea that, they were targeting everybody, liberal groups as well, that is false in your judgment, correct?
It's absolutely false. The records don't substantiate that, and I know that that's one of the things that people have been using since last summer as a means of trying to discredit or to thwart the investigation. I'll give you one example. There was a report that was released published in USA Today last September, which was an internal IRS document that listed 162 organizations that were on the watch list or development list at the IRS. And I think the number that was calculated was 83% of them were conservative. I'll give you the example. This was a document prepared in November of 2011. King Street Patriots is listed on there, and it says on the report, likely approval. November of 2011, likely approval. Also on that list is one of the few liberal groups, Progress Texas, and references in the comments that this is an organization that appears to engage in anti-Rick Perry propaganda. November 2011. Fast forward, Progress Texas gets its tax-exempt status by May of 2012. King Street Patriots did not get its tax-exempt status until 2 months ago after going through yet more rounds of questioning.
Thank you for that. I'm about out of time, so I just want to ask Mr. Sekulow, what the administration is trying to do with the C4, is it safe to say that if that is in effect, that would disproportionately affect conservative groups? In other words, a lot of the labor unions and environmental groups would not be affected by that. Is that correct?
Correct, because a lot of those are exempt under different provisions of the Internal Revenue Code. But in that regard, and with regard to the questioning aspect of this and the chilling effect, which I think is, Congressman, what you're going after, we have a client, the pro-life organization, that is one of the ones targeted. The questions to them were so draconian in nature that this is what they asked. Talking about the client's pro-life position. This is the IRS. The presentation of viewpoints or positions are unsupported by facts is a significant portion of the organization's communications. The facts that purport to support the viewpoint or positions are distorted. This is coming from an Internal Revenue Service agent. The organization's presentation makes substantial use of inflammatory and disparaging terms and express conclusions more on the basis of strong emotional feelings than of objective evaluations. And the approach used in the organization's presentation is not aimed at developing an understanding on the part of the intended audience or the readership because it does not consider their background or training in the subject matter. Who gave the IRS the authority to say this, and how is it that the President of the United States can say there's not a smidgen of corruption when the documents, by the way, some of these signed by Lois Lerner or Holly Paz? How could they possibly even say this? The thing I don't understand, Mr. Chairman, is as the President was making his statements, as members of this committee were making statements, we had the documents in our possession, and I know Cleta did as well, from offices all over the country, coast to coast. And the agents told our clients it was being managed out of Washington. And with the email that was released yesterday, we know how high up the chain. And I would urge the committee, when you start talking about associate chief counsels, divisional counsels, this is as high as it gets.
Well said. Gentleman from Pennsylvania is recognized.
you were involved,
no corruption there at all. No.
that's not what I'm
Flat.
saying. That's actually
No, but I want to know what you're saying. You're the leader of the country.
Absolutely.
You're saying no corruption. None.
No, there were some boneheaded decisions out of a
but
local
no mass
office.
corruption.
Not even mass corruption, not even a smidgen of corruption.
I'm interested in having a balanced investigation, and I am a balanced hearing. And in that light, Ms. Eckelbrett, did you hear the president say there was not a smidgen of corruption?
I've heard that he said that, yes, sir.
Ms. Garrison, did you hear the president say there was not a smidgen of corruption? And let me just translate that, because smidgen's not a legal term. I assume he meant scintilla, and I assume he meant criminality instead of corruption. How was he able to make that conclusion? Neither of you have been interviewed by the Bureau, have you?
No, sir.
And according to Mr. Sekulow, of his 41 clients, 3 have been interviewed, or 3 were asked to be interviewed.
Right. Not interviewed yet.
Okay. 0 of 41 have actually been interviewed.
Correct.
All right. So the president says there's not a smidgen of criminality or corruption. Do either of you remember seeing a witness named Lois Lerner sitting at the very table y'all are sitting at? Do you remember her invoking her Fifth Amendment privilege, the same privilege that she targeted some of your groups for trying to educate people about? Some of your groups just want to simply educate people about the Constitution, the one that she availed herself of the very second she was exposed to criminal investigation. So how can the president say there's not a smidgen of criminality when Lois Lerner invoked the Fifth Amendment? 41 witnesses haven't been interviewed, including the 2 that are here right now. How can he possibly draw that conclusion?
Good question.
I wish one of the colleagues on the other side of the aisle would ask the president how in the world he concluded no criminality when Lois Lerner sat in front of them and invoked her privilege against criminality. How do you square that?
Mr. Gowdy, if I may, she invoked her Fifth Amendment privilege, which she has the right to do, of course, and you and I both respect that, because we now know the reason why. It wasn't perhaps as clear as it was made yesterday. She invoked her Fifth Amendment privilege because she knew, after she made a false statement and a planted question at an ABA meeting, she knew that, in fact, there was her words and her emails, off-plan drafting of rules targeting conservative groups. She also said at a Duke Law Forum that people are asking us what we can do, and she said, I can't do anything until I see the 990s, the tax returns that are filed. That was all going on while she was redrafting the rules with the highest level of the Chief Counsel's office. Mr. Cartwright.
Mr. Sekulow,
yes,
I want to say this. I understand why she invoked her Fifth Amendment privilege.
Mm-hmm.
I don't understand why in the hell the President of the United States would prejudge an investigation
I don't either.
before any of your clients were interviewed, before either of these 2 victims, and I know you don't like that word, but I'm using it in the criminal sense of the word, before either of these 2 victims were interviewed. He has gone on national television. He has prejudged the investigation, and in my judgment has compromised the Department of Justice, which leads me to this question, Mr. Sekulow.
Yes, sir.
There is the option, when you have a compromised investigation and a chief executive who has prejudged the outcome before the jury's even gotten all the evidence, he's got an option of appointing a special counsel, right?
Yes, he does.
And the special counsel regulation says if it's extraordinary circumstances that furthers the public interest. Can you think of anything more extraordinary than government targeting people based on their political beliefs?
No, I agree with you 100%. And I also would point to the email of June 14, 2012, which was just released, because this shows the need for a special prosecutor at this point on the criminal aspect of this. And again, Mr. Cartwright, when you asked about the no evidence of politics, let me quote from the email. Don't know who in your organization is keeping tabs on C4s, but since we mentioned potentially addressing them off-plan in 2013, I've got my radar up, and this seemed interesting. These are coming from the most senior people within the chief counsel's office of the IRS, which is a presidential appointee. Again, it's an office I came out of, so I have due respect for the office. But at this point, a special prosecutor to evaluate the criminal sanctions or criminal laws applicable would probably be the best, I believe would be the best way to go, because I don't think the Justice Department right now, again, with due respect to the Justice Department, is institutionally capable of doing this. And I need to say this also, because I thought that the question, Mr. Cartwright, on Ms. Mitchell's legal representation, she has an exceptionally excellent reputation in this town as a lawyer. And her clients tend to be conservative because that's who her clients tend to be. But, you know, I'm a conservative also, but like I said, I've represented the American Civil Liberties Union in cases at the Supreme Court of the United States. I've represented the National Democratic Policy Committee as well. So I don't think it's fair to go after the lawyers in a situation where it is the IRS that is trying to use their procedures to justify their illegal conduct. Remember the apology? They offered the apology. You know what? The apology is not accepted.
Mr. Chairman, in conclusion, I believe the ranking subcommittee member said that there are 13 people assigned to this investigation, if I heard correctly. 13 people in 6 months have not had time to interview a single solitary one of Mr. Sekulo's clients. 13 people in 6 months have not had time to interview either of these two witnesses, and yet the chief executive, the president of the United States, has already prejudged the outcome of this investigation. So either it's ongoing or it's not. Either he's wrong or Eric Holder is wrong. In either case, it is time for special counsel, Mr. Chairman.